We also have a sentencing in People v. Gregory Frisky. It's file 24-6860FH.
Thank you. Brian, could you have Greg Frisky's post counsel to my right? Your Honor, I'm going to ask the court respectfully to adjourn Mr. Frisky's sentencing. Mr. Frisky today has expressed some misunderstanding and frankly displeasure with the work that I've done for him. Without going any further, I think he wants to seek the advice of alternate counsel. I would not be comfortable continuing on with the sentencing in this case based on the conversation we had without going into details.
Okay, well, Mr. Frisky, we are here for sentencing, and you knew it was for sentencing. There's a mandatory minimum jail for this offense. So I can't just start having people show up for their sentencing who don't want to go to jail and say, I'm unhappy with my lawyer, kick it down the road. So I'm happy to adjourn it so that you can explore whatever with Mr. Clayton or another counsel, but I'll be remanding you to jail today nonetheless and canceling your bond. So you can't, like, just by saying I'm unhappy, avoid going to jail today. If that means you need another minute to talk to Mr. Clayton, I'm happy to give that to you. But I'm not going to have defendants just show up for their sentencing and say, I'm unhappy, and walk back out that door. Do you understand that?
Yes, Your Honor.
So whatever happens next, you're going through that door. You understand that?
I was misinformed.
I don't care. Whatever happens next, you're going through that door, and we'll sort it out later. I'm happy to sort it out later, or we can do your sentencing now. Your choice.
Mr. Frisky wants to adjourn sentencing to explore.
Okay, that's fine. And I wouldn't want to put you in a position of going forward when you don't feel comfortable with that either. So we'll continue the sentencing to September 9th so that it's less than the mandatory minimum amount. So it won't prejudice Mr. Frisky at all. We'll continue the sentencing to September 9 at 1:20 p.m. And that's the time you're here anyway, Mr. Clayton, because Mr. Clayton is still attorney of record until anything changes about that. And I am going to order Mr. Frisky's bond to be canceled and remanded to the custody of the Sheboygan County Sheriff until further order of the court. And we'll see you next on September 9th at 1:20 in the afternoon.
Am I supposed to go get that breath thing, bring that in, or?
I'm going to the jail right now.
I'm sure I can get it back.
Yeah. I've gotten this, I've got a attorney. Is that all you have, Mr. Clayton? All right, good afternoon. We're on court for the County of Sheboygan. We are providing public access both in this courtroom and online. And good afternoon, Mr. Clayton.
Good afternoon, Your Honor.
I did sign the stips on Taylor and McCumbee.
I appreciate it.
We brought Mr. Frisky out in the courtroom. People v. Frisky 24-6860FH. We adjourned the sentencing a couple weeks ago at the defendant's request. And then given some scheduling issues with his attorney, I'm told that Mr. Frisky has no objection to his attorney appearing by video today. Is that correct, Mr. Frisky?
Yes, sir.
Okay. Mr. Clayton, have you had a chance to review the pre-sentence report with Mr. Frisky?
I have, Your Honor.
Any additions, corrections?
No, sir. I was going to say, I'm also the opinion the guidelines are scored properly.
Okay, thank you. Ms. Goodrich, guidelines were scored at 0 to 6. Any scoring challenges or additions, corrections?
No, Your Honor.
The only correction, I guess, would be now that we've adjourned it a couple of weeks, Mr. Frisky would, of course, be entitled to that additional credit. So by my count, that'd be an additional 14 days, bringing him to 15 days credit. Mr. Klain, anything you want to say on behalf of Mr. Frisky?
Your Honor, this case obviously had a little bit longer path to get to where we are. We did try a couple different specialty court options that just weren't available to Mr. Frisky. And I don't need to go any further than that. He made the attempt. I think that you're looking at a case where you have a guy, he's got 2 drunk drivings about 20 years ago, roughly 20 years ago. It doesn't seem like it's a habitual kind of situation for him. But I have talked to Mr. Frisky at length, and it's a stated intention that he's going to gain and maintain sobriety for life. It's a lifelong commitment for him. I think he's better. I think society is safe if he's not drinking. Certainly not drinking and driving, but if he's not drinking, the court shouldn't have any concerns about that. He did apologize to me about last time we were in front of the court. I told him, I said, that's not necessary, but it happens. People get upset. These are big situations, and I'd ask the court to follow the recommendation. The only addition I'd ask the court to do is Mr. Frisky, at least the last I talked to him, was still gainfully employed. I'd ask the court to consider allowing him to participate in a work release program so he can get back to work. But short of that, I think the recommendation of the state minimum mandatory required under the statute is 30 days. I think with the 0 to 6 guideline range and his age prior record, I think that recommendation is appropriate. I'd ask the court to follow the same.
All right, thank you. Mr. Frisky, it's not required you would say anything today, but it is allowed. Is there anything you want to tell me, sir?
I just like to apologize. I did to the attorney that it wasn't in my intention to not take whatever was coming to me, but I just didn't have enough time to get my affairs in order at my house.
Okay. All right, Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. We are here because on April 3rd, 2025, the defendant had crashed into trees. He had received minor injuries and had a 0.198 blood alcohol level. He's 65 years old. This is his first felony. He has 4 prior misdemeanors. His 2 prior drunk drivings were 2002 and 2006. He is employed with a high school diploma. The guidelines are 0 to 6. We do have a sentencing agreement not to exceed those guidelines. I agree with the PSI recommendation for 30 days with credit for the 15 days served. However, it is concerning that he stated he usually drinks a couple and then hits the road. That was an unusual statement for somebody with 2 prior drunk drivings, and he still seems to be in denial about how serious the drinking and driving can be and how to prevent it. Thank you.
All right, thank you. Well, Mr. Frisky, if you'd please stand for the court's pronouncement of the sentence. Your attorney and the prosecutor have both accurately laid out your history with criminal history and alcohol. And you're here for operating while intoxicated third offense sentencing. It carries a 5-year maximum. The advisory guidelines are 0 to 6. Because the 2 priors were so long ago, I think the recommendation, there's a mandatory minimum 1 month. Lots of folks, including your lawyer, will tell you it's not very often that an OWI third case gets only the mandatory minimum, because there's usually such a pattern of behavior going on that there's more incarceration than the 1 month. I think in this case, given your lack of prior felonies, the age of the priors, that's why I think the recommendation is just for the mandatory minimum. I think under these circumstances, that does appear to my mind to be appropriate. So I'm going to follow those recommendations. It is within the advisory guidelines. It is within the terms of the plea agreement. So I'm going to place you on probation, Mr. Frisky, for 12 months, subject to the terms and conditions listed on the pre-sentence report at pages 2 and 3. Those include, of course, support group meetings, substance abuse assessment and treatment, community service, employment, crime victims assessment of $130, monthly supervision fee to the Department of Corrections, court costs of $350, fine of $500, $250 OUIL reimbursement, comply with DNA testing and pay a $60 fee, $68 in state cost. And I'll order that you serve 1 month in the Sheboygan County Jail and give you credit for 15 days previously served. I think that's too short of a sentence to really facilitate the work release program, so you wouldn't be eligible for that, but you'll be out within a couple weeks or less, depending on good time. Also, on the judgment of sentence will indicate that any weapons that were seized will be forfeited to the agency that seized them, consistent with the plea agreement. Mr. Frisky, you are eligible to petition for discharge from probation early at the halfway point or beyond if you've successfully completed all of its terms. So we're going to hand you a piece of paper explaining that process. Also, if you wanted to appeal, you could do so by filing an application. If you wanted a lawyer appointed, you'd have to ask within 6 months. So we're going to hand you a piece of paper explaining that appeal process. We're going to ask you right now to initial 1 copy of the appeal paperwork so we have a record that we gave it to you. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Frisky? Within 24 hours of your release, I want you contacting probation department to get going with your supervision. Anything further from the defense, Mr. Klan?
No, sir. We thank the court.
Anything further from the people?
No, thank you.
Okay, we're all set. You have a good day, Mr. Klan.
You as well. Thanks, sir.
All right, and then we have a probation violation.